Hi, everyone. Today we're at the Department of Labor. We have Marina with us today. Marina, thanks so much for joining us. Marina, can you first tell us who are you, and then eventually just tell us, how you got to the position that you're at?
Yes, first of all, thank you for inviting me. My name is Marina Reynoso, and I've actually been with the department for 23 years. I started in 2000 as a unemployment insurance claims adjudicator. I did that position for about 7 years, and then I transferred to the wage and hour division. So currently, I've been with wage and hour for 15 plus years now.
Okay, great. Uh, let's go into Marina the person first. Are you from here? Kids, family? What does that look like for you?
Well, I'm actually I was born in originally from Mexico. Our parents migrated to the United States when I was about 4. So I've been in the States for several years. We currently live in Nampa. I am happily married for 38 plus years with my husband, Manuel. We have 3 adult children, and we have 3 grandkids.
Nice. Um, I'm just curious. Where did you guys meet? You and your husband.
My husband and we met in Mexico. Actually, I went on vacation to visit our grandparents, which was kind of like a custom that our parents would take us to Mexico, like sometimes during the Christmas when schools gave us Christmas
Hmm.
break. And I met my husband there. We dated for 3 years, and then he asked me to marry him. He used to play professional soccer for
Oh, cool.
Guadalajara, so I told him, well, if you're willing to move to the States, I think I'll accept. Otherwise, I don't think I could live in Mexico because I've lived here, most of my life. Although I was born there, I was raised here in the States, so I just couldn't see myself living in
Right.
Mexico.
Hmm. Well, that's great. 38 years. Before you go into like the nuts and bolts, any tips for anybody to help their marriage last 38 happy years?
I think the key to a good marriage relationship is having communication between your spouse. Always be open to having that communication. Have respect, and I mean, we all go through ups and downs, but I think that those are 2 key things for us as a couple: to have respect for each other's and have open communication.
Nice. I think that's great because I think the 38-year plus marriages and stuff. I feel like it's harder and harder to find these days. So thanks for giving us a little bit of your pearl of wisdom. So Marina, can you just tell us a little bit, just a general overview of what the Department of Labor does, um, who it serves, what the purpose is, just very high level. And then can you just tell us more about your specialty, the wage and hour division?
So the Idaho Department of Labor is one of the state agencies that offers different services to the citizens. There are different offices throughout the state, and as the Idaho Department of Labor, the unemployment insurance program is administered through the Idaho Department of Labor. So citizens can go to the offices to get assistance when they're looking to update their resume, or if they need to use equipment like computers or fax machines or copiers. Those are available to the public in our office. If somebody's looking for work, they can assist them in getting registered to look for work. Employers can post listings if they're looking for to hire somebody. So those are some of the services that are offered throughout the offices. My area of work is in the wage and hour division. So as the wage and hour division, we're assigned to administer the wage payment laws, the minimum wage law, and we also license the farm labor contractors. We're outstationed employees. We're kind of scattered in different offices throughout the state. There's 4 of us in the state and our supervisor. We have a compliance officer in our Post Falls office. We have one in Idaho Falls, and our supervisor is in Pocatello. Another coworker works in our Boise office, and I'm outstationed at the Caldwell office. So again, as the wage and hour division, our main duty is to administer the wage payment laws. Anytime that somebody works for an employer and they aren't paid their wages, they can file a wage claim with us. We'll do an investigation to try to get them their wages paid if they're due.
Okay, that sounds great. So who is typically, I guess the better question is, how does somebody take advantage or just research, find, and take advantage of this resource?
So, for example, if somebody's working with an employer and for some reason they're not getting paid for all their hours worked, but they really don't want to lose their job at the moment, and they just kind of decide to pursue it later, um, there is some time to do it. There's some statute of limitation. When a person has worked for an employer and they've never been paid any of the wages due, they have up to 2 years to file the wage claim. That's 2 years from the time the wages were due. If that employer paid them a portion of the wages, but they owe them additional, then that wage claim has to be filed within 1 year. Our wage claims are filed online. It's an easy process. It probably takes maybe 10, 15 minutes at the most if the person has all their information with them at the time that they're going to file, because they're going to need the employer's business name, the address, their dates of employment, and a couple of other questions that they get asked. But it's a fairly easy process. After the wage claim is filed, then we call the worker first to get all the details of what happened, what attempt did they make to get their wages paid. After we get the information from the worker, then we call the business to kind of give them a heads up. It's just a courtesy call to let them know that a wage claim has been filed. We verify their address to make sure that we're sending it to the right place. And then afterwards, then we send the employer copies of all the documentation that was provided to us by the worker, along with a cover letter which explains the loss. And it's a process. Initially, we give the employer 14 days to respond. And if they respond, we send that correspondence to the worker, and the investigation can go back and forth a couple of times. If we don't if we don't get it resolved at the end of our investigation and the worker still insists on wanting their money, then we review everything on file, we apply the laws accordingly, and we write a determination. Both parties will have a right to appeal that determination.
Okay. So I think earlier, well, when we were talking earlier, you mentioned it's up to $5,000, right? So can you tell us more about what qualifies under your department or your division?
Yes, there is some criteria in order for a person to be able to file a wage claim with us, and one of them is the dollar limit has to be $5,000 or less. If somebody is owed above $5,000, then we cannot process that wage claim. That worker would have to pursue it through the district court. They would have to hire an attorney. Another criteria is that in order for us to be able to enforce the wage payment laws, we have to determine that there's an employee-employer relationship between the two parties. So if the worker was an independent contractor, a true independent contractor where they had established their own business, and a general contractor doesn't want to pay them, we can't help them. Those are settlements that have to go through the court. So if it's under 5,000, if there's an employee-employer relationship, then we can assist them with the filing of the wage claim.
Okay. And I don't know if you can say or not, but if people are under the table kind of workers, I think they're still able to process a claim. Is that right?
Yes, the fact that they're paid under the table, I mean, that's really, a method of payment. It's not necessarily unacceptable. I mean, cash is money. But when a person is paid under the table, they still have the right to file, because we're still going to do our investigation. And through our investigation, if we find that that employer still owes them wages, just because they were paying them under the table doesn't mean that that worker has given up their rights. We'll still follow through with our process. And once we conclude the investigation, if we determine that they truly were employed, then we will be able to enforce the wage payment laws. We always ask employees to try to keep their own record of hours, because sometimes employers that pay under the table, they tend to not have, a valid record keeping method. And so they tend to want to deny that the person even worked with them. because they don't have any hours or anything like that. So as long as the worker has kept track of their record of hours, to start the investigation, they can provide us whatever they have, whether it be on a piece of paper, written on a calendar, or wherever they have those hours written. We'll accept that. We will mail that to the employer. If the employer doesn't dispute it, if they don't respond, then we may end up writing a determination based on whatever documents we received from the worker. So that isn't a factor for the person not to be able to exercise their rights.
Right. I think that's good for people to know. Um, Besides the record, people taking their own record keeping for, if they're an employee, what are some other just tips that you can give people to make sure that they protect themselves and they have all the right like information or criteria?
Well, I always recommend that employees, every time they get their check, they should take a look at their pay stubs. Sometimes, we tend to look at our pay stubs because there's so much technology that's being used nowadays. Employers have our pay stubs available online, and we know that it's being direct deposited, so we don't even bother to check to see if we got paid correctly or if there were any kind of deductions that weren't authorized by law. So one advice I would give the workers is to um, don't always just trust that you're getting paid all the hours worked and all the wages due. Make it a habit of checking your pay stub to make sure that the employer is paying you for all the hours worked, that they're not making deductions that are not authorized by law. Sometimes employers will make deductions that are not necessarily taxes, but other deductions that may not be authorized by law. For example, in order for an employer to withhold wages from a paycheck besides the taxes, that employer has to have the employee's written authorization. One example would be if the employer provides uniforms and they want to be able to make a deduction from a paycheck if that worker does not return the uniform, well, that employer would have to have some kind of payroll authorization deduction form signed by the worker, which would be at the time that they're hired, somewhere in their policy, basically stating that if they don't return that uniform, they are giving that employer written permission to withhold the wages from the check. If that employer has that document on file and the worker doesn't return the uniform, then that employer can withhold it from the paycheck. If the employer did not have them sign anything and the worker did not return the uniform, that employer does not have a right to withhold the wages from the check. So those are some of the types of claims that get filed through us. Also, when people separate their employment, sometimes they have a balance of vacation on the books. Although Idaho is a work at will state and the law doesn't require vacation pay, whenever an employer offers it, it becomes wages. So if an employer doesn't want to pay out a balance of vacation that's left on the books, they have to have it written in policy. Some kind of verbiage like we have a use it or lose it, or we don't pay out vacation upon separation, or if you quit without notice, you lose your vacation. So as long as it's written in policy, they won't be required to pay it out. But if there's nothing said in a policy about the worker not being able to get paid out their vacation, then they'll have to pay it out upon separation.
Yeah, I was going to actually ask you that as far as on the employer side. What are some tips maybe for the employers from the cases that you work with? So, like policy, making your policies are updated or have the right kind of language. But is there anything else that you can kind of tell them?
Sometimes we'll get calls from employers. We don't write policies for employers, but we can certainly review their policy. Like if they have a policy and they're not sure that their verbiage meets our law, they can contact us. We'd be happy to review the section that would apply to the wage payment laws. So again, we're not attorneys, we don't give out legal advice, but if they have a handbook or a policy and they're not sure if what they have written in it applies to our wage payment laws, we can certainly have them email it to us. We'll take a look at the verbiage and we'll give them, suggestions like what you have written doesn't meet our law. You'd have to reword it in order for it to comply with whatever section of the law we're kind of taking a look at.
Mm-hmm. Okay. Was there anything else in your wage and hour? I know you have a presentation that. Oh yeah, that's another thing. You do presentations for people, right? Um, Companies, schools. What is in? How does somebody schedule one with you? And then also, what are I don't want to take away from your whole presentation, but what are some highlights in there that maybe you haven't gone over yet?
Actually, if there's a new business that's just getting started, and I've had some calls like if there's a new business that just got started and they really don't know a lot about, what are the wage payment laws in the state of Idaho, um, they can always call me, and sometimes I can schedule like a one-on-one. I'd be happy to kind of go over all the wage payment laws with them. The department schedules group presentations for employers, and I get invited to those. And so usually those are, you know, they're set up in advance, and they put out the dates on our homepage when they have them coming up. But if there's not one coming up soon, and there's an employer that would like to, just basically know what are my responsibilities as an employer under the wage payment laws for the state of Idaho, because they could be different. If they're coming from another state and they're starting a business here, they could be different. They can always call me, and we can, schedule an appointment. And I'd be happy to kind of go over some of the basics. For example, like, in the state of Idaho, whenever an employer fires somebody or somebody quits, there's a certain amount of time that that employer has to issue that final paycheck. So in the state of Idaho, once a separation occurs, and it doesn't matter if the person quits or gets fired, that employer has to issue that final paycheck on the next regularly scheduled pay date following their separation date, or within 10 days if the 10 days come sooner than the pay date, or within 48 hours if they get a written request. 48 hours can be in the form of a text. If the employer replies to the text, then we can enforce the 48 hours. If the employer does not reply to the text, we cannot enforce the 48 hours, because the burden of proof is on the worker to prove that they gave that written request, and we count the 48 hours from the time that that employer replies to the text. If an employee requests it via email, if the employer replies to the email, then we can also enforce it. So we tell employers, make sure to educate your management staff, your supervisors, that if they reply to a text when a worker is requesting their check within 48 hours, make sure that supervisor communicates it to your payroll department or to your HR, so that that check can be issued within that 48-hour time frame. If you don't issue it without the 48-hour time frame and the worker decides to file a wage claim to pursue penalties, because it is written in law, that employer may be subject to penalties of up to $750. That's additional money that would have to be paid to the worker on top of the wages owed. So those are some of the, some of the things that we see. Some of our, the majority of violations that come in like that in regards to when an employer doesn't want to comply with that written request because they think, well, you quit, I shouldn't have to pay you within 48 hours. Sometimes, like if an employee gives a notice to quit within 1 or 2 weeks, sometimes employers don't want to allow them to continue working. If that employer says, no, I want you out of here today, that's legal. You can do that, and you're not going to be required to pay them for the remainder of the week or the 2. I know some states are different. Idaho's a work-at-will state, and so there's a lot of things that aren't necessarily required, in the state of Idaho, that some other states have different laws, but Idaho law doesn't require breaks. It doesn't require holidays off. It doesn't require raises. There's no limit on the number of hours that an employer can require an employee to work in the state of Idaho, as long as that worker is 16 years of age or older. If they're under the age of 16, then per the child labor laws, there are some restrictions on the hours that they can work, and they have to provide minors breaks.
That's interesting. I don't think I even knew a lot of those. No breaks, no raises, holiday work. Is there anything else that we didn't cover yet that you wanted to promote or plug?
Yes, I would like to advise employers that it is the law that employers have to provide employees a pay stub every time they issue a paycheck. If you provide the pay stubs available online, you have to make sure that the employee is educated on the program, that it's available, so they know how to download it in case they want to print a paper copy, or if they don't have a computer or a printer available at home, then that employer has to make that pay stub available if the worker wants it in a paper form. But it is a permissible method. Also, some employers, have been utilizing like they pay with pay cards. That is also an acceptable method, although we don't really recommend it that much. But under the wage payment laws, it says that an employer can pay in lawful money, whether it be cash, money order, cashier's check, or direct deposit on a voluntary basis. So because the law says direct deposit, when employers started to ask about debit cards or pay cards, we kind of said that, okay, we will accept it like the direct deposit that's written in the law. It has to be on a volunteer basis at no cost to the employee, and the employee has a right to revoke it at any time. So if you pay with a pay card, it has to be on a volunteer basis at no cost to the employee, and they can revoke it at any time.
Is there like a Spanish like assistance, like if people need it,
I'm bilingual.
But around the state though, is there, if there's the Post Falls, someone in Post Falls, needs someone who speaks Spanish or something, assuming that person doesn't, is there services for those people to kind of get help?
On just wage payment laws or on?
Like if they want to seek advice or they want to, put a claim in and stuff and they only speak Spanish?
Well, currently I'm the only bilingual in the wage and hour division. So most of those calls will be routed to me.
Okay.
A lot of times people will want to come in person and I'm always open. Currently I'm working 2 days in the office and 3 from home, but in March I will be 3 days in the office and 2 from home, but I'm always on the phone available. But if people prefer to come see me in person, I don't have a problem with that. But yes, there isn't a question that we can't answer over the phone. So if somebody goes into our Post Falls office seeking assistance and they don't have a wage and hour person that works there, they're going to direct them to the phone in the lobby and they're going to have them call me and I'll answer whatever question they have.
Okay, so you guys cover
yes
each other, it looks like.
Another thing that I'd like to mention is the wage payment laws that we administer only apply to private sector businesses. So these laws that we enforce do not apply to city, county, state, or federal government. They only apply to the private sector businesses.
Okay. So the government entities, where would those people go?
Usually we would refer them to U.S. Department of Labor, or sometimes those are matters that have to go through the court. But for the most part, we would give them the number to the U.S. Department of Labor's Wage and Hour Division.
Okay.
Overtime, we don't enforce the overtime. It's a federal law, so we don't have jurisdiction. So for example, if somebody is owed 45 hours and 5 hours of those are overtime, we can help them with the 45 hours for straight time pay. If they want to seek the overtime portion, they'd have to go through the U.S. Department of Labor, or they can go through the U.S. Department of Labor for all 45. But if they file with us, we're not going to be able to enforce. That doesn't mean they're not owed it, but we don't have the authority to enforce the overtime because that's federal law. But we have knowledge on it, so if somebody calls and they're not sure, whether this employer is supposed to, there are some exemptions to overtime, like farm work, over-the-road truck drivers, mechanics, seasonal employment, salaried exempt employees. So those are all occupations that are not subject to getting paid overtime. So, we can answer basic general questions because since that is federal, a lot of times we refer them to the USDOL so they can get the information from the experts.
This might just be a naive question on my part, but I'm just curious about somebody puts a claim in, you go through the process, they're owed money legitimately, and then the employer just doesn't do it. What happens at that point?
So after we finish our investigation and if the employer ends up not paying and we've reviewed everything on file, we've written a determination which becomes a legal document, and we've determined that they're owed wages, that legal document gets mailed to the employer and to the worker. It gives the employer 14 days to pay or appeal. After the 14 days, if that employer does not pay or appeal, then we transfer that claim to our collection department because Wage and Hour has a collection department. So the process is still followed, it's not dropped. So then the person that works collections takes it over from there. he or she will get a hold of the employer, says, hey, this claim is now in collections, you didn't pay it. You have 30 days to pay or make payment arrangements. If the employer then doesn't pay it after the 30 days, then the person that works collections will start sending writ letters to the banks. And if that employer has money under the business name, then that's where the
Oh,
wages will be paid.
okay. So
They'll,
it's paid either way.
yeah.
Okay.
Well, the only problem would be is if the employer has closed out their bank accounts and there's absolutely no money out there, then sometimes claims could go uncollected. But the person that works collections continues to kind of, look into, see if the employer has opened up the business again and stuff. So the good thing about our department is that we do have a collections department. A person can go through the small claims court. If they don't want to file with us, that's also an option. It's either small claims or us. The small claims court doesn't have a collections department. If you get awarded from the judge, here's your award letter, you're on your own to collect. With us, we do have a collection department, so
Okay.
that's the advantage. Other than that, the same laws are enforced.
So it's nice to have the extra advocacy,
Mm-hmm.
it sounds like,
Yes.
to the employer and then the after part. So,
Mm-hmm.
um,
And we're definitely here, we're a neutral party. We're neither on the worker side nor on the employers. Our job is to enforce the laws as they're written. And so we're here to educate the employer and the worker so that both parties know their rights. And we understand that employers are busy and they don't want to have to take the time, taking our phone calls and us taking their time away. So, we're here to assist the employers. If they have any questions before they make any deductions and they want to make sure that legally they can do that, or hey, can I, this person has tools, can I hold their check until they bring it in? Call us and we'd be happy to answer those questions so that these workers aren't filing claims and us calling you to take up your time. Or any question that you have that you think might be in our area, we're here to assist them.
that sounds great.
Mm-hmm.
Okay. Well, Marina, thank you so much for taking some time to just talk with us, help us be aware of wage and hour, a little bit about just the Department of Labor in general. And yeah, thank you so much for just taking time to just help our citizens and make just us aware. So,
Thank you for inviting me. It's been a pleasure. And, I just want the citizens to know that we're here to answer whatever questions they may have. And feel free to call anytime. I'm at the Caldwell Job Service Office. Our number is 208-332-3579. My direct extension is 3195. But any of us in Wage and Hour can answer their questions.
great. Thank you.
Thank you.